And I'm pleased to be able to speak in this debate despite not being a member of the committee. Committee members, clerks and witnesses are to be congratulated in a very detailed interim report which flags up a number of important issues which need to be addressed if the Smith Commission recommendations are to be properly implemented. As others have said, it is particularly commendable that the committee managed to reach consensus between 5 political parties on matters which are controversial, because that consensus makes this report all the more powerful. And I hope that the UK Government will therefore consider the issues raised with the utmost seriousness. The convener talked about intergovernmental relations, and Linda Fabiani, at the end of her contribution, indicated she would have liked to have said a bit more about the Sewell Convention. In fact, it was the committee's recommendations regarding the Sewell Convention and legislative consent memorandums which stood out to me as I looked through the report. The committee stated that the current draft clause 2 does not incorporate in legislation the process for consultation and consent, where Westminster plans to legislate in a devolved area. The Law Society expressed concern to the committee that the draft clause does not place the Sewell Convention, whereby the Westminster Parliament does not normally legislate with regard to devolved matters without the consent of this Parliament, on a statutory footing. Professor Alan Page of the University of Dundee observed that, quote, it would be preferable for that to be made clear on the face of the legislation. I am concerned that the current situation should not be watered down. I want to see the need for consultation, and consultation with adequate time to do so, to be strengthened. Because despite the Law Society stating that the Sewell Convention had worked relatively well, our experience during my time on the Justice Committee is that it has not always been satisfactory. And if I could ask members to cast their mind back to the Legislative Consent Memorandum on the Antisocial Behaviour, Crime and Policing Act, which we passed on the 22nd of January last year. Although we did somewhat reluctantly agree to that legislation, the Justice Committee was sufficiently concerned about the proposals to criminalise forced marriage that we could not make a recommendation on that part of the LDem, and we asked the Parliamentary Bureau for a short debate. In that particular matter, members will recall that the Scottish Parliament had already passed our own legislation, the Forced Marriage, etc. Protection and Jurisdiction Scotland Act 2011, which was deemed thereafter to be in contravention to the Istanbul Convention. Scottish organisations representing women's ethnic minority groups hadn't had the opportunity that their sister organisations in England and Wales had to respond to the UK legislation. They were unable to put forward their view on how the Scottish Act was working, and in particular their arguments about why they felt it was not in contravention of the Convention, although indeed legal advice the committee received contradicted that view. There were also major changes in the maximum sentence for the criminal offence, which again were introduced in Scotland without consultation. I should again make it clear that it wasn't the policy intention that was a concern in this instance. It was the lack of consultation with Scottish stakeholders and the possible conflict with our own legislation. We were faced with the choice eventually between accepting an LCM which hadn't been subject to consultation in Scotland, or introducing emergency legislation here. And that's a path which we all know is strewn with pitfalls. And reluctantly, most of us accepted that the LCM was the better route. But committee members strongly felt, and I'm sure others could back me up on this, that the LCM process was flawed. The Justice Committee has also received other LCMs on Criminal Justice and Courts Act and the Serious Crime Act, for example. These were prompted by amendments introduced in the House of Lords. Now, though most of these hadn't been as sensitive as a forced marriage issue, there had been very little opportunity to receive evidence while adhering to the short timescales required for this Parliament to consent to the LCMs. So the Justice Committee, I think, has not found the LCM process to be ideal with regard to the opportunity for consultation prior to giving consent or otherwise. And I am therefore very concerned that this draft bill weakens the process rather than strengthening it. I'll give you an example. The UK Government's intention to scrap the Human Rights Act of 1998 further compound my belief that the LCM process has to be strengthened with regard to consultation and consent. This Scotland Act places obligations on this Parliament with regard to human rights. But if the Human Rights Act is repealed and a weaker British Bill of Rights is introduced at a UK level, we might receive LCMs which could contravene the legislation which founded this Parliament. It is clear that the vast majority of members of this Parliament are opposed to the repeal of the Human Rights Act, and if it is repealed by the UK Government and replaced by something weaker, it may be the decision of this Parliament to pass our own human rights bill to protect human rights in those areas which are devolved. We may wish to do that. What happens then? UK legislation could be compliant with the provisions of the British Bill of Rights, but in contravention with the Scottish Human Rights Act. And this Parliament could be presented with LCMs which are incompatible with our own legislation. And I think human rights is one important example. But as responsibilities are devolved to this Parliament, there will be an increasing potential for divergence of legislation and therefore complications if the UK Government seeks to legislate in devolved areas. So I think it is therefore essential that this clause is redrafted to reflect the need for consultation and consensus. And can I just conclude by saying that I very much agree with the convener that the UK Government really does need to get this bill right before it is introduced into Parliament at the UK level. I think that some of these are serious issues for concern, where we could become conflict between the Parliaments, conflict between this Parliament and the UK Parliament if we don't get these things right. And I think it's necessary for intergovernmental relations that we do so.
Many thanks.